All right, you guys ready to go?
Yep.
Good to go.
All right. Good morning. Before we get going, can I please confirm with council that you can see and see all three of us and that you can hear me, Mr. Waugh?
I can, Your Honor.
Ms. Ryan?
Yes, Your Honor, I can. Thank you.
All right. Welcome to an oral argument session of the 6th District Court of Appeal. My name is Dan Traver. I'll be presiding over today's panel. We have one case on the docket. I'm joined today by the Honorable Keith White and the Honorable Petra Brownlee. Our one case is case number 23-2204, Mika and Nuzat Coates versus Anthony and Sharon Spoto. This is being streamed live on YouTube, just so everybody's aware of that. Typically, Mr. Waugh, the counsel for the appellant will have 5 minutes rebuttal as a standard, but if you want more or less, say the word and we will make that happen.
Thank you, Your Honor. 4 minutes would be fine.
We'll set 4 minutes for rebuttal, and you may proceed at your convenience.
All right. May it please the court, Mr. Chief Judge, and Your Honors. I'm Christian Waugh, appearing on behalf of appellants, the Coates family. My clients' appellants are parties to a contract as buyers for a piece of residential real estate. Appellees refused to sell that property at closing, and so my client sued for specific performance. The trial court's judgment against my clients denied them specific performance, and it's wrong for at least 3 reasons. I think the first one is the most important. It's the one I'll focus most of my argument on, and that's that the trial court erred by failing to interpret the plain language of the contract. The court focused on this one particular provision, which is numbered number 2 in section 20 of the contract, almost to the exclusion of all others in rendering the final judgment. This is a standard FAR residential contract in almost all respects, except for the custom language that's in that section 20. And the term I want to direct the court's attention to is the following. It says, sellers and buyers agree that in the event of a new roof being provided by the insurance claim, the sellers will provide evidence of the new roofing, and the roof must be permitted, completed, payment satisfied, and the insurance claim closed and free of construction liens on or before the closing date, or total escrow deposit will be returned to the buyers. Now, paragraphs 3, 4, and 5 of the final judgment is where the trial court essentially held that number 2 was a contingency to consummating the entire transaction.
Mr. Waugh, can I ask you before you pivot from that point, when you just read that to us, the last section, or I guess the last couple of words of section 20.2 state or total escrow deposit will be returned to the buyers. So if this is not, if section 22 is not a contingency, then why would the total escrow deposit need to be returned to the buyers?
Oh, because it's an amount of money, because it's $20,000 that would then compensate the buyers for the fact that a new roof was not provided by the insurance company.
But they would still have no down payment, so to speak, toward the home, toward the purchase of the home. Is that correct?
Well, they'd still have to bring money to closing, Your Honor, but the 20,000 at least would compensate them for the fact that insurance didn't bring a new roof to close. And I do take the court's point. I mean, obviously the trial court said that deposit language has to be a contingency, but usually when something is supposed to be a precondition or a contingency, it says so. And it doesn't say that. It says the deposit goes back. And I'd also point out that actually in the contract, we know what a contingency looks like because it actually says so. And in Section 8, there's a financing contingency. The buyers have to go get financing, and they've got 30 days to do it. If they don't, it could be a contingency to the contract. It says so. And so I think it's really important that I think this question highlights what really my main argument, which is that when something is a contingency or a condition precedent, it normally says so, or it should say so. Otherwise, we've got the plain language of the contract here. Now, it doesn't say that if Section 2 isn't fulfilled, that the parties go their separate directions or that seller is alleviated of their obligations to close. It just says in the event that a new roof is provided by the insurance claim. I'm not even sure we get to that language. Actually, I'll give the court a hypothetical. Let's say the insurance company does provide a new roof, but there's still a dispute over the amount of payment and they've got a lien on the property. Then in that case too, the deposit goes back to my client and maybe that helps cover the lien. So this is, I think it's actually a pretty well drafted provision that is not a contingency. Now, I guess to me that makes a lot of sense, and it makes.
Can I ask you then? So if we look at those things, if that section of 20.2 is contemplating because the insurance company is replacing the roof, then your clients would get the deposit back because they don't have to pay for the roof, correct?
Actually, the way I read it, Your Honor, and that I think is the plain language, is that they only get the deposit back if two things happen in that section. Number one is that the roof is provided by the insurance company, and it's not all cleared out. In other words, there's potential liens on the property. I mean, here's what the language. It says it has to be of equal color, shape, and materials. The roof must be permitted, completed, payment satisfied, and the insurance claim closed and free of construction liens. And if that doesn't happen, then they get their deposit back.
So I guess what you're explaining to me then is essentially that your clients would otherwise be paying for the new roof, correct? Under your interpretation of that provision. But go ahead.
Oh, no, I didn't mean to interrupt, Your Honor.
Oh, no, that's okay. I thought you had an answer to something. So if that's true, if it's contemplating that your clients would be paying for the roof, can you help me understand why in 20 point, and it's misnumbered, but in 20.3, which I think should be 5, it states that sellers will agree if the insurance claim is ultimately denied, so the insurance company is not going to be paying for the new roof, then they're going to reduce the sales price to $705. So therefore, if it was denied, your clients would not be paying the amount of the roof. Instead, the sellers would be paying the amount of the roof. Is that right? And is that consistent with the idea in 20.2 that your clients would be on the hook for the payment of the new roof?
That's not entirely right, Your Honor. And the reason is that it's not the case that section, I call it 20.2, contemplates that my clients would pay for the roof. That deposit is meant to defray the risk of what happens if they get a roof provided by the insurance company and there's still issues with it. So it's all the language in that last sentence that's important. If the claim isn't closed, if it's not free of construction liens, what if there's a contractor who, puts a lien for work on the property for $10,000 and it's not cleared by the time of closing? So that deposit then goes and it helps my clients handle the problems that might still exist from the roof that is provided by the insurance company. It does not contemplate that my client pays for the roof at all. And I think that's why 20.3, let's call it 20.3, says what it says. And that's why we raise it as the second error in this argument, this idea that the claim wasn't ultimately denied, because we would be asking this court not just to vacate the judgment, but to have the trial court award specific performance at that lower purchase price, because that's what should have happened. The insurance company didn't have a roof. They didn't provide a new roof by the time of closing. And because the claim had been denied under the facts of the record, my client should be entitled to buy it, not at $715,000, but at $705,000. In any event, I really want to try and show the absurdity of construing 20.2 as a contingency. And I guess I would direct the court to 20.1. In 20.1, it says sellers will pay utility assessments until closing, and the buyers will assume the remaining balance after closing. Well, under appellee's reading and under the trial court's reading, that might as well just be a contingency too. But this is really just a covenant of the contract. This is something they didn't do. And if my client still wants to proceed to closing, as they did, they were ready, willing, and able to close, that's on them. And it's especially the case when a seller is clearly trying to get out of a contract. They raised the point in the answer brief that, and the trial court mentioned this too, that there's these addenda that the parties were trying to negotiate before closing. And on the record, it's clear why they were talking about the addenda to extend the closing date, because my clients found out through third parties that this litigation was ongoing. They knew that sellers were trying to get out of it so that they could get more money for the property later on. And when they wouldn't agree to the extension, if anything, that's what shows the bad faith in the first place. We've provided the court case law in our initial brief that talks about situations where a seller shouldn't be able to benefit from the fact that they create litigation to get out of their obligations at closing. I think that's the Jevis v. Fernandez case at 905 Southern 2nd. It's a third DCA case. But what the court there said is it's well settled that a seller cannot take advantage of a delay in performance that he or she created. I submit to the court that's exactly what happened, because it's undisputed that the sellers engaged in litigation, and they could have just gone ahead and repaired the roof as required by the contract. They didn't do it. I mean, at the end of the day, if my clients want to proceed and buy that property, then they should be able to. And for whatever reason, both sellers and trial court disagree. We think under the plain reading that the court doesn't even need to get to any of these other.
Mr. Waugh,
Yes,
with respect to the last argument about it being bad faith, so is your argument that it's bad faith? Well, let me step back for a moment. You agree with these provisions we're talking about, 20.2, 20.3, that there was a contemplation, there was going to be an effort to try to get this roof replaced by the insurance company?
Yes, Your Honor.
Okay. And so if the sellers try to do that and they have a contract which they believe requires the insurer to pay this claim, and then the insurer denies the claim, it's bad faith for the contracting party to seek to get the defaulting party, i.e. the insurance company, to perform?
No, Your Honor, it's bad faith to seek to get them to perform after closing and to insist on not fixing the roof as required by the contract by the closing date. In other words, the claim's denied in October and the closing date's in February. So I don't think anyone would begrudge them trying to get the insurance company to cover that between October and February. But insisting on continuing the litigation past February is, and maybe bad faith is strong, but it's not good faith. And they have an implied covenant of good faith under the contract not to engage in dilatory actions that just extend things. In other words, it's not an out, Your Honor. And there's no contingency in the contract that says it's an out. What it says in the contract is Either the company provides the roof or you do. And if the company doesn't, then you've got to do it. And maybe they didn't want to do it because they'd be getting less money from the purchase price, but that's what the contract requires them to do.
But Mr. Waugh, when you referenced 20.3, and I keep looking to my left because I have the contract pulled up on my second screen here. So under 20.3, the language is ultimately denied. So you referenced before Judge White asked you a question, it's denied as of the time of closing. But so help me, how does the plain language of this contract where the parties put in ultimately denied? Ultimately, I'll be candid with you. To me, ultimately means ultimately at the very end. But you're asserting that it's what is the state of that claim at the time of closing? And so where in the contract is that to be gleaned from?
Well, it's not. Well, all we have in the contract is the ultimately denied, Your Honor. So I think that's all I can tell you in terms of the language that's in the contract. What I can tell you is that in the record of the trial, they brought Appellee's own attorney to testify, and she testified not only that it was denied, but that it stayed denied even after settlement. So that nothing about the settlement changed the fact that the claim was denied. It was Appellee's own, I don't know how they got her to testify, but she did testify. And she said, under great cross-examination, by the way, that the claim was denied. And if you can't accept, I think, the attorney's representations on this for Appellee's, I mean, there's no other evidence. And so
isn't there some kind of, I mean, we've got the denial of the claim, and I've gone through the record and I understand what you're pointing out to me. And I do think that was the case. However, there is also the fact that they ultimately, however they achieved it, they ultimately receive the money from the insurance company. So it seems like, isn't it really neither of these? There wasn't a payment of the claim at the front end. There's not a denial of the claim ultimately, because at some point, the buyers do receive a sum of money from the insurance company, which they can then use to repair the roof.
Actually, I think this happens every day in lawsuits where parties don't make admissions. There's specific no admissions provisions and settlement agreements. It doesn't change the fact that something's denied on the record and stays denied, but some party settles and makes a payment. And that is exact. In fact, I can't imagine a situation in the state of Florida where this could ever be construed as anything but a denial that stayed a denial because, or that was a denial at the time that the insurance company made it, because if it was anything else, and insurance companies could be construed as not denying things through settlements later, they'd be running out of the state faster than they already are. And so I also think that, so I think it's kind of, unless something operates to change that, paying money doesn't mean it wasn't a denial. It means there was a settlement. Now,
But isn't the point of the contract whether or not the buyers received money to repair the roof? And if they receive money to repair the roof, we're under 22. And if they don't receive money to repair the roof, we're under 23. I mean, isn't that sort of, I mean, it seems to me, and you're saying no. So what's the point of the denial if not that?
Well, Your Honor, I see that I'm going over my time. Once I answer the court's question, I'll be quiet. But no, Your Honor, respectfully, I think the point of these provisions is not the denial, it's to protect my clients to get a roof. So the fact that the insurance company denied the claim, did not provide a roof by closing, put the burden on the sellers to do that. So I'd like to reserve the rest of my time, Your Honor. Thank you.
Ms. Ryan.
Thank you, Your Honor. First, I would like to point out that the appellees never refused to sell the property at time of closing pursuant to Section 20, subparagraph 2. They weren't able to close. The paragraph specifically says that all of this has to be done on or before closing. And it is standard practice in real estate in the state of Florida. If you have a clause like this in your contract, it can't close if this hasn't been met. Therefore, it is a contingency.
Where do you see the language, counsel, that says all of this has to be done by the time of closing? Could you point me to that? I have it pulled up.
Yes, Your Honor. if you look.
I mean, that would make it, that would be an important fact, I would think.
Yes, Your Honor. It specifically says on or before the closing date. That's at the very right before the total escrow deposit would be returned.
So that would presuppose though that it's coming under 20.2. But if 20.2 is not satisfied, we would look to 20.3 to see if then perhaps there was a denial, correct?
Yes, Your Honor. But in this case, there was no ultimate denial pursuant to that paragraph. And additionally, if you look at the paragraph 3, it's not just that it has to be denied. It is also that the sellers have to be released from their liability and obligations from the roof contract. They were never released from that obligation. In fact, when this contract between the buyers and the sellers was entered into, the contract that the Spotos had entered into with the roofing contract and the attorney representing them in the insurance claim was past the rescission date. Each contract had a 3-day rescission date. And in order to get out of that, they would have had to ended up paying some type of penalty. In fact, and with that, the law is clear that they have to act in good faith, but they're not required they're required to make reasonable diligence, but that does not require them to go to extraordinary efforts or expenditures. And to have to pay a penalty in getting out of the roof contract to satisfy paragraph 3 would be an extraordinary expenditure that they were not required to do. But again, Your Honor, we argue that subparagraph 3 never came into play. At the time of closing, the insurance claim had not been ultimately denied. It was being litigated. The appellants had argued that they didn't have the right to file a lawsuit, but there's nothing in the contract that prevented them from doing so. And the fact that the parties did try to extend the contract is very telling, that the parties knew that this contract was going to lapse on February 16th if they weren't able to close under paragraph 2. They couldn't come to a meeting of the minds. Therefore, the contract on February 16th, when it did not close, because these conditions were not met, lapsed. They no longer had a contract. Therefore, there was.
Also, will you respond to Mr. Waugh's argument that the record is replete with evidence demonstrating that the claim was denied? There are admissions to that effect. And so why isn't that dispositive of section 20.3? What are we to do with that?
Yes, Your Honor. The insurance claim was originally denied, but that's not what paragraph 3 says. It says ultimately denied. In the end, the insurance claim was settled. It was paid. The insurance company provided a new roof. So paragraph 3 never kicked in. If the word ultimately was not in there, then I would argue that, yes, the appellants are right. Subparagraph 3 would apply. But ultimately, it was not denied. It was settled. It was paid. Counsel's argument that the attorney for FLE said that the claim was denied even after settlement is inaccurate. When it's settled, I don't recall her ever saying it was denied after settlement. It was denied prior to settlement. Once you settle it, that denial is gone. The only thing the insurance company failed to do was to admit liability. Didn't say they denied the claim. If they denied it, they would have never paid it. That's the way insurance companies work. They cannot pay a claim and still deny it.
It's interesting to me that the trial court ultimately found that these provisions were unambiguous because it seems like both of you are discussing a situation that wasn't contemplated by the contract.
Yes, Your Honor. In my view, I did find that the term in subparagraph 3, in my opinion, was ambiguous as to multiple attempts, as not defining that. But as far as subparagraph 2, there is no dispute as to the clear language. And the clear language in that is that those items had to be done, they had to be met on or before closing. And in Florida, if something has to be done on or before closing, closing cannot happen if they're not done. Therefore, the contract lapsed when the parties could not come to a meeting of the minds on an addendum to extend the contract. And again, it wasn't one attempt to extend. The appellants had offered an addendum, but they had changed some of the terms in the additional language. My clients were not agreeable to that, so they counterproposed. That was not agreed to. My clients, even in a good faith effort, after closing, presented another addendum that was rejected by the appellants. To say that my clients acted in bad faith and that they didn't want to close this deal because they knew or thought they could get more money by selling to someone else is disingenuous at best. In fact, the testimony at trial from Mr. Spoto was that they didn't want to sell. They weren't putting it back on the market. They never put it back on the market. When the contract lapsed, they decided they didn't want to sell.
The back and forth as it related to the appellant's initial argument today was going so well that I didn't get a chance to ask a question. I'll ask it of you, and maybe Mr. Waugh at his discretion can address it in his rebuttal. But would you speak a little bit to the standard of review as it relates to specific performance? It occurs to me that the complaint, which wasn't filed by appellate counsel, only sought equitable relief. It didn't seek monetary damages other than the out-of-pocket, say, for the Airbnb. So as I understand it, specific performance is going to be reviewed under an abuse of discretion by the trial court. Every judge on this panel is a former trial court judge. I think it's safe to say that we were more excited about abuse of discretion standards than de novo review from the appellate court. Could you address the particular standard of review on specific performance and how it ought to bear in our decision?
Yes, Your Honor. Under the abuse of discretion, the trial court's discretion on the issue of specific performance can only be disturbed if it is clearly erroneous. And that is stated in Voigt v. Key Island, Inc. That's at 374 Southern 2nd, 1035, Florida 2nd, DCA, 1979. In this case, there was no clear erroneous decision of the court. Under that standard and under that ruling under Voigt, the court
Are you anchoring the discretionary standard in something other than discretion? Are you basically saying that we need to decide whether the trial court interpreted the contract correctly in order to decide whether it abused its discretion in accepting or declining to impose a specific remedy? Because it seems like your answer is more of a de novo sort of review on our part, which would be, I think, much more exciting for the appellants.
Yes, Your Honor. Specifically under the case law that I've cited, it specifically says that the trial court's denial of specific performance has to be clearly erroneous for the appellate court to overturn it. it's a very high standard when it comes to specific performance. Florida case law is also clear that specific performance is not granted as a matter of right or grace, but as a matter of sound judicial discretion. And only when the plaintiff is clearly entitled to it, there is no adequate remedy at law, and the judge believed that justice requires it. The plaintiff was required to meet all three of those elements for specific performance. And I feel in this case that that was not done. Even under adequate remedy at law, the return of their deposit is adequate. They also, I would argue that they could only claim this remedy if the SPOTUS failed to use reasonable diligence. And in this case, as I've previously stated, reasonable diligence is good faith. It doesn't require them to go to extraordinary efforts or extraordinary expenditures. So therefore, they failed to meet their burden for specific performance at the trial court and even here today, Your Honor. And counsel had briefly hit on their argument of waiver, that they were ready, willing, and able to close. However, because of subparagraph 2, with the contingencies in there, as the court determined them to be contingencies, and I believe the clear language is clear that they were contingencies, they would have to have actually waived those contingencies. And even in the contract, paragraph P requires any changes to be in writing and signed by the parties, and that was not done. At no time did the appellants say, we're ready, willing, and able to close. We're going to waive this. You don't have to do this. And therefore, even their argument of waiver, I believe in this case fails, Your Honor. And we therefore respectfully ask the court to affirm the final judgment in full.
So what is your response to Mr. Waugh's characterization of the phrase "or total escrow deposit will be returned to the buyers"? Do you agree with his interpretation of that? That's in 20.2.
No,
that
Your
it's sort
Honor.
of protecting the buyers, so to speak, from something that could go wrong if they repair the roof or if they're somehow on the hook for the roof?
No, Your Honor. Again, if those things were not done by closing couldn't happen. And it's only logical that the escrow deposit would be returned. And in fact, in this case, the SPOTUS attempted to return the escrow deposit pursuant to this paragraph, and the appellants refused it. And that in itself was a breach of this contract on the appellant's part. And I know counsel had argued that it was because they weren't getting a new roof. Well, if they weren't getting a new roof, that would then paragraph 3 would have applied, and they would have had a reduced sales price. So they're getting their deposit back and they're getting a reduced sales price because they're not getting a new roof. It's a little disingenuous.
Anything more you'd like to add?
No, thank you, Your Honor.
Any other questions from the panel? All right, Mr. Waugh, rebuttal.
Thank you, Your Honor. First, I want to address the court's question about the standard of review. I had the same question, and it turns out that the case they cited in the oral argument is a great case, but it doesn't say, I think, what they think it says. So in Vorp v. Key Island, Inc., second DCA case, it does say that it has to be clearly erroneous for specific performance. But the court in this case doesn't actually, what the appellate court held is the court's erroneous determination that it could not act to grant specific performance preempted its own discretion. In other words, the court made a mistake on a de novo reading, so it didn't even get there. And so I guess what I would suggest to this court is, if the court did agree with appellants on the interpretation of section 20.2, the court has different remedies it could do. It could send it back for various determinations. But, the second thing I want to bring up in rebuttal is this, the idea of this waiver argument, the idea that if something is in writing, that the contingencies say that they can only be, everything has to be done by closing. Number one, almost all the terms in this contract have to be done by closing. It does not mean that they are contingencies. I'm talking section 12B, a warranty provided by closing. It is not a contingency unless it says so. Second of all,
aren't there, Mr. Wall, aren't there items in these, you won't like this word, but let's just call them contingencies or these additional terms, okay? Because I understand that contingencies is a huge point of contention here. However, if we just label them additional terms and it's your position that because they benefit your clients, your client has the right to waive them, aren't there also some terms in here that would benefit the sellers, such as in 20.2, that they would have to be, I can't locate the language right away, but essentially that they would have to no longer be on the hook for any sort of roofing contract or anything. Like, aren't there things in there that they would have to waive?
No, Your Honor, I don't think there's anything in there that actually protects the sellers. The idea there, in other words, the contract has to be, the roof has to be perfect. And if it's not perfect, my clients get the deposit. So it's just an obligation on the sellers. If it's not fulfilled, my clients benefit from it. But
what about the seller? What about in 20.3, sellers are then released from their liability and obligations under the roof contract? Because if we don't have that and they could be on the hook for a new roof contract, or something under that, wouldn't they be the ones that need to waive it?
No, Your Honor, because as shown in the trial court record, undisputed between the parties, these provisions exist to protect my client. In fact, my client had a prior contract on the property and it was canceled because of this roof issue. Testimony on the trial court is that all 20.2, 20.3, there to protect my client. Great case on this. Visible Difference Inc. v. The Velvet Swing, 4th ECA case mentioned in our brief, talks about how even when it says that these things have to be in writing, or even when it says that they all have to be fulfilled by closing, a party can unilaterally waive them if it's for their benefit. So thank you, Your Honor.
Thank you very much for the submissions in this case. It'll be taken under advisement and we'll be in recess. Hope everybody has a